In this episode of No Holds Barred, we're going to talk about sexual assaults, principally in the area of civil law rather than criminal law, but I do want to touch on some of the connections between civil and criminal law as it relates to sexual assaults. And sexual assaults is a wide category. It can mean rapes, molestations, seductions, a number of things. So let's get right into it. The difference between civil and criminal law is that in criminal law, the sanction is you go to jail, you go to prison. In civil law, it's money. You collect money. The differences don't vary much in terms of what's being charged or what's being alleged. Let's talk about the civil side of things. And oftentimes, we would have cases referred to us to help people work through being witnesses as victims in criminal cases. And we would help them through simply because I had a great deal of experience having headed the sexual assault unit of the Contra Costa County District Attorney's Office. So I had a lot of experience with cases like that. But at any rate, we'd follow it through, and then we'd see the incredible damage done to victims even after a criminal case was completed. Because for them, there was really no satisfaction. Maybe the bad guy went off to prison, maybe he went to jail, maybe he didn't go to jail at all. But what did they have? They had nothing, and generally, they didn't even have enough money to pay for the kind of counseling that they needed. So we got involved and started to say, well, wait a minute, let's look at some of these cases. The easy part for many of them was the person was already convicted of a crime. So all we had to do was get a certified copy of the judgment of conviction, and that part of the case was already over, the liability phase. And then we get into the causation phase, or how much money it was worth, how it damaged them. We'd refer them to psychologists or therapists. So that's kind of the difference between the two. What I really want to talk about more is some of the cases that we had, and I'll just tell you, we had the rape of a housekeeper for a significant period of time. She was an immigrant, was afraid she was going to be deported, and her landlord was the person who continually molested her, raped her over a long period of time. He was prosecuted, and we got involved in that case. We went to trial, and then we got a judgment at trial of $10 million. Pretty satisfying to get a judgment like that. Another case is a neighbor kid who was continually molested by the neighbor. And he would come over. They had all kinds of fancy computers and things, and he was attracted to that. And this person would prey on him. And he too was prosecuted and convicted and sent to prison. We brought a civil action. I want to let people know that insurance now generally does not cover that kind of intentional tort, the kind of intentional act by the perpetrator. However, his wife was present all during the times the kid was over at the house, and oftentimes the kid was molested in the bathroom in the master bedroom. And so they had to walk past the wife in bed. And we implicated the insurance for the homeowner's insurance for the wife, and we were able to get a settlement for her negligence. And that recovery was something pretty satisfying. So there are lots of ways to go about this. I do want to talk about the statute of limitations, though, as it applies to children and to adults. As to children, the law has changed in 2019. Pretty significant change. It used to be if a child was molested as a minor, and I want to say for the law, it doesn't matter whether somebody's emancipated or what, a minor is somebody under the age of 18 for purposes of our sexual assault laws. And so if somebody's molested under the age of 18, they had till age 26 to bring an action, and that was what the law is. More recently, in 2019, the law has changed, and now it is to the age of 40. Plus, there is a window from 2020 of 3 years. So that 40 doesn't necessarily apply within this 3-year period of time. And we're in it right now. It's very important for people to understand. So somebody much older then 40 can still bring an action. There's certain parameters in that action that they have to be concerned about. And you have to get a certificate of merit from your lawyer, but also a certificate of merit from a therapist who has examined that person, the victim. And that therapist who gives a certificate of merit cannot be the regular therapist for that person. So as a practitioner, as a lawyer, what you want to do is you send that victim to somebody brand new, a therapist, who then interviews, does whatever they need to do to come to an understanding that, in fact, yes, they believe that the person was molested, and that, in fact, they've been damaged, and they then consult with the lawyer, and the lawyer puts a certificate of merit together, and that's how, that's how it gets cared for after the age of 40. But I do want to say, very important, that that's going to be a small window. We have heard about cases where somebody has been molested as a child. Much later in life, they go to therapy, and it all comes out. And that's different than this law that we're talking about. There can be a civil case brought when somebody is much older than that for a case in which the molestation took place when the person was a minor, and that is only if, through therapy, it all came out. They didn't appreciate the damage to them, they didn't appreciate the danger to them, and they do much later. So we've had several cases like that. In a case of a long-term molestation as a child, person was all messed up, the victim, just a bad life, drug abuse, all kinds of things, and much later in life went through therapy and appreciated that all of the problems that she had, many of which were based on this terrible molestation that she had perpetrated against her from the age of 13. So there are lots of ways to go, but I do want people to kind of appreciate it's important to look at it, look at those statutes, and see whether or not there is a case for them on the civil side. Again, I want to say on the civil side, only money is what you can get. There's nothing else that you can get. And people often say, well, I just want satisfaction. Well, you may get satisfaction or you may not get satisfaction, but principally lawyers will handle the case because they're looking for money. We had a case in which another neighbor child was in fact molested by somebody. The perpetrator was arrested, was convicted, and was sent to prison. Just before he went to prison, his wife said, I'm done with him, and divorced him. He signed over the house and all the property to her. We looked at that and said, well, there was no consideration for that. In other words, his 50% of the estate was his 50%. And he gave it to her really simply to say, I'm going off to prison, I'm never going to use it, but also to hide it from anyone who might come afterwards. So we filed a suit. We had a discussion with the wife's counsel about the fact that 50% of that estate actually belonged to him, and we wanted it for our victim. And really, you think for the venal interest of lawyers, look at it, we're just in it for the money. You know what, we've gotten into it mostly, in most cases, to try to get some recovery so the victim could get some therapy for the rest of their lives, perhaps get schooling paid for and all that, and we've been successful in doing that, and that's a wonderful thing. There's not a lot of money out there to help victims. There is a victim program through the state of California, and in some cases that allows for some therapy, but oftentimes, if we go in and get a recovery, they want some of that money back. So there's a lien on the part of the state in some of these victim recovery units, and it's never enough money to really handle things long-term for somebody over the course of their lives. So I think it's important to look at these cases. And we know more in recent news, religious organizations or organizations which Boys and Girls Clubs or Boy Scouts and Girl Scouts and all those kinds of things, those organizations happen to be in the news, unfortunately, because we can look back and see that there were molestations and potentially a long history in some of the organizations. And sadly, some of those organizations didn't do what they should have done back at the time of these events. So getting back again to insurance, there is insurance for many of those organizations, and that's what steps in to help in recoveries. But from a homeowner's policy standpoint, there's generally no recovery whatsoever for the actual perpetrator, but the newer should have known. So if somebody in the household was present, should have known, did know. We did have a case in which a young girl was within a program where she wanted to be a model, and her parents put her into this, and the photographer had, we can make you, we can do all this, we can make you a model. And she relied on him. He molested her significant periods of time, and she felt she needed to put up with it because here's this person who was going to make her a star. Never made her a star. Never made her a star. When we filed suit, though, we named him, but we also named the organization, his company, which was a corporation. And his private insurance did not cover it, but his corporate insurance did cover it, and we were able to get a nice recovery for her over time. So there's lots of good news. There's bad news in many cases when people miss the statute of limitations. It's a he said, she said, and they're unable to prove it. The prosecution takes a look at it and says, well, we think it happened, but we don't know, and there's no evidence to support it. So, but we always tell people, come to us and let's talk about it. At least we can have a discussion. We can walk through what the evidence is. We can walk through whether or not there's insurance. We can walk through whether or not there's some potential for recovery. And we can certainly walk you through the issues of the statutes of limitations, both on the criminal side and on the civil side. One little bit of new law is the 10-year period of time, and that is, as an adult, bringing an action within 10 years of the last event. So you can think about, from a criminal standpoint, you worry about statutes of limitations, and I'm not going to go into them today. That's not the purpose of this no-holds-barred episode. But from a civil side, the last event. So if you think of somebody in an adult in a position such as a teacher, that photographer, or somebody, a coach, that you look at, when was the last time, and if it's within 10 years, we can bring an action on the civil side. I do want to talk about it. Kind of goes back to all the time people say, well, consent. Wait, he or she consented to this. Let's talk about minors. Minors cannot consent. So we used to look on the criminal side of somebody under the age of 15 or whatever, but a minor can't consent. If an adult takes advantage of a minor, they don't get to say, well, they consented. So in that case that I talked about where we had somebody in his 30s and the girl was 13 when it first started, saying, well, she consented. All these years. No, she can't legally consent to that, so you can bring an action. Now, we have statutory rape cases, and the boy's 18 and the girl's 15 or 16. Those get filed, if they get filed criminally, or generally filed as misdemeanors when the age is not particularly great, and they're actually kind of in a dating relationship. But we're not talking about those cases. We're talking about somebody who's in his 30s and the person is 15 or 16. No, there's no consent there. But that's the first offense, and we often hear about it. And we've heard of some schools lately of, kids. Can you have a rape case with kids when they're both minors? Well, of course you can. Why? It's consent. There is no consent. And we tell people nowadays, young girls or boys or whatever, just say no. Make sure you say no. Make sure that it's very clear that you're not consenting to that act. Difficulty for us in civil and criminal cases is when we look at something and the victim, a week later when mom is mad at the person for coming home late or whatever, well, I was raped. Well, did you tell anyone? Did you tell any of your friends? and what are the facts behind it. And those are very difficult cases to bring, because you want to say, why didn't you bring it sooner? Well, sometimes the person was too traumatized, and that certainly is something we want to take a look at. Were they too traumatized? Was it a person, a professional, somebody in a position of authority? So a religious figure, a coach, we see that all the time. And I didn't want to bring it. I didn't want to get cut from the team. I was afraid, and so I didn't bring it. And you can think of cases such as that. In some cases, the cases actually come forward by a friend. So the victim confiding in a friend, you know, Mr. McGillicuddy has been molesting me for years and years. My God, did you tell your parents? No, I was afraid to tell my parents. Particularly difficult in boy-on-boy molest. So a man molesting a boy, and in our world, somebody feeling like, gosh, I you know, the neighbor molested me, but I sure didn't want to tell anyone about it because I don't want people to think there's something wrong with me. Well, there's nothing wrong with you, nothing wrong with you at all, except that you were molested, and that's a big thing. Now, molestations are of many kinds, as I said, professionals, coaches, neighbors. Rape is a different story. Rape is non-consensual penetration, and we talk about sexual assaults many times. Misdemeanors in the criminal side are an offensive touching a girl on her breasts or massaging her butt through clothing. In many cases, is charged as a misdemeanor. Sexual battery, lots of those. However, if it's a position of authority and the person feels coerced and I have to put up with that, I don't like it, but it's just on my outer clothing, but over a period of time, can be filed as a felony. And when those cases happen, we look at them from a civil standpoint and say, okay, well, there's certainly something to be said for that, particularly if it's an organization, as I said. And again, getting back to that insurance coverage, or whether or not somebody has enough value in their home or enough money to go ahead and pay for it. So as a result of some of the changes in the law, old stories are coming back. For example, Michael Jackson. So some people are looking and saying, kind of fishy how he paid off some parents over a number of years ago. But with this new statute, there is the potential even against his estate. So if you, a close friend or relative, or someone you know believes they've been molested, and you want to explore your options, reach out to us. It's very important. Or reach out to an attorney you're comfortable with, because it's very important, particularly with these new statutes, which open the door for victims for violence, sexual violence that happened years and years ago. So very important for you to reach out to us, or as I say, to someone that you're comfortable with. Explore those options, and we can help you look at the law, we can help you look at the facts, and we can help you decide whether or not you'd like to move forward with this. So that's it for today's episode. I'm Matt Guichard of GTP Lawyers. Stay tuned for the next episode of No Holds Barred.